Major breaking news and good news out of the state of Hawaii. A Barack Obama appointed judge, Leslie Kabashi, has ruled that much of Hawaii's sensitive places rules, which is a euphemism for gun-free zones mandated by government, is unconstitutional under the Second Amendment and has entered a temporary restraining order. Stay tuned. We're going to talk all about it. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Don't forget to follow me on Twitter at Four Boxes Diner and check out my book. It's now available on audio as well as on Kindle. All right, folks, major breaking news and good news. The state of Hawaii, Judge Leslie Kabashi, a judge appointed to the bench by Barack Obama, has applied NYSERPA versus Bruin to strike down many aspects of the new anti-Bruin mass resistance attempt to enact gun control law by the state legislature of Hawaii. Specifically, Judge Kabashi has declared many aspects of the so-called sensitive places rules to be unconstitutional. Specifically, the judge out there in Hawaii has declared that the following laws in Hawaii are likely unconstitutional and thus will be enjoined on a temporary basis pursuant to a temporary restraining order. Specifically, the court found that the portions of the Hawaii statute that prohibit the carrying of firearms in parking areas that are owned, leased, or used by the state or the county, meaning government, where the parking area is shared with non-governmental entities and not specifically reserved for the state or county employees, or do not exclusively serve the state or county buildings, those parking lots are no longer sensitive places, quote-unquote, government-mandated gun-free zones, because it violates NYSERPA versus Bruin that says you can't just declare large swaths of land to be gun-free zones. That violates the Second Amendment and the clear express command of the Second Amendment that says you have the right to bear arms, which means the right to carry in public for, among other reasons, self-defense. So that's the first portion of the law that Judge Kabashi declared was likely unconstitutional. She then goes on to say that the ban on firearms in bars and restaurants that serve alcohol is also likely unconstitutional, which makes a lot of sense because many restaurants and diners, bars, they have liquor licenses, but so what? Who cares if they serve alcohol? Why does that matter? I mean, like every Greek diner in New York City has a liquor license as far as I can tell, but so you go in there to have breakfast, you're not even vibing alcohol or anything, and yet somehow you can't bring a gun in these places. It's absurd. Nevertheless, in Hawaii, I'm happy to report that the judge has declared that that law is likely unconstitutional and will be hereby enjoined. Then she also says that the law prohibiting firearms in banks and financial institutions likewise will be enjoined temporarily. The judge also said that it is likely unconstitutional and thus will be enjoined prohibitions on the carrying of firearms in beaches, parks, and their adjacent parking areas. And last but not least, she said, and this is important, this is the so-called default rule, that the portion of the Hawaii statute that prohibits the carrying of firearms on private properties held open to the public is also unconstitutional and will be enjoined. That last provision is particularly important because it's a new angle that the anti-gunners are trying to take, which is to declare all private property in a state to be an anti-gun, no guns allowed zone unless the proprietor puts a big sign out front that says guns are welcome here, forcing them, of course, to be compelled to articulate their political views, or many people just don't want to get involved and won't put up the sign, even though they don't care that there's guns involved. And I will give the judge credit here. She specifically says, what's the big deal? If you're carrying a gun concealed with a license, no one even knows you have it. So why does this even come up? It's not like the owners are even going to know you have the gun because it's concealed, which is the whole point of the law. So nevertheless, I think this is all good news. I will say one interesting thing, as she did point out, effectively, this is a Bruin resistance bill because she writes that on June 2nd, 2023, the Hawaii governor, Josh Green, signed this bill to clarify, revise, and update Hawaii's firearms laws to mitigate the serious aspects of gun violence and all this. So obviously this was in response specifically to Bruin, another mass resistance attempt by Hawaii, but it's not going that well for Hawaii. Now, I will make one observation about this court opinion, a myth she articulated. And so this was sort of a bad sign up front, but she ultimately got it mostly right. And on page 2 of her opinion, which is 91 pages, that's right, I read 91 pages for you all. Happy to do it. It's a lot of work, a lot of footnotes, a lot of details. Nevertheless, in her 91-page opinion, which I'll put a link to down below in the description. I try to always do that. I don't always get a chance to do that because sometimes the links are not available or things like that. But I try really hard to do that, and I'll try to do that here again. But she specifically writes the following. This is a myth. But again, she ultimately got a lot right, but this is what she wrote, and I think this is wrong. She says, quote, "It is this powerful collision between Hawaii officials' concern for safety and the welfare of its citizens and the Second and 14th Amendment protections of the individual right to carry a firearm. It is not a powerful collision. It is not a collision at all to allow Americans to exercise their fundamental right to carry a gun in public. That in no way, shape, or form harms or endangers public safety. As we know from the Founding Fathers' highly influential philosopher, Cesar Beccaria, laws that ban the carrying of firearms only help the criminal class and harm the law-abiding innocent class. So there is no collision between allowing Americans to carry guns peacefully for the purpose of self-defense and public safety. If anything, those individuals enhance public safety because they make it harder for criminals to attack. Because as Cesar Beccaria said in the 18th century that our founding fathers loved, including John Adams and Thomas Jefferson, an unarmed man can much more easily be attacked than an armed man. A lesson our founding fathers well understood, which is among the reasons why they adopted the Second Amendment's right to keep and bear arms and codified that pre-existing right. Nevertheless, this judge indicated there's a powerful collision here. There's no collision at all. It's entirely consistent with letting Americans protect themselves against the scum that's on our streets, as well as allowing government to protect Americans from the scum that's on our streets. It's all consistent with the same goals in mind. There's just a few additional points I think it's worth noting from this very powerful 91-page decision by Judge Leslie Kabashi. She specifically talks about how this basically forcing businesses to take a position on gun control is a constitutional problem. She specifically says, and this is very interesting, she says that one of the plaintiffs here, by the way, I should mention that this is a suit sponsored by the Hawaii Firearms Coalition, represented by the lawyer Alan Beck, who's had a lot of major Second Amendment victories. So congratulations to the Hawaii Firearms Coalition and to Alan Beck and to the other two plaintiffs in this case, Jason Wolford and Allison Wolford, as well as I think it's Anton Kaspreki. I hope I pronounced that correctly. I apologize if I didn't. But again, you'll see their names down below in the caption of this opinion against the government of Hawaii. But specifically, what the judge says here is that Mr. Kaspreki owns and operates his own business along with associated business property and space. His business is open to the public, and he states that some of his clients do not support the concealed carrying of firearms, and as a consequence, he does not wish to involve his business in any issues related to the Second Amendment, even though he supports it. And this is exactly right, because he says he does not want to put up a sign or otherwise give prior written or verbal consent to carry a firearm for obvious reasons, because he doesn't want to hurt his business. And I could not agree more. He says that, of course, this compelled speech violates the First Amendment, which I think it does. So again, a good point, and this is a good way to establish standing. So if you're representing anyone out there in one of these default provisions that says you can't bring a gun on private property without consent, take a look at the affidavit and materials submitted by Alan Beck, in this case involving the Hawaii Firearms Coalition, because there's some good guidance here, perhaps helping you craft your declarations, affirmations, and affidavits for those litigators out there. The other thing I want to mention that I think is very powerful from the judge here is she talks about the notion of presumptions. Now, this is very important, and this is a game the anti-gunners like to play. They like to pretend that the fact that the Supreme Court talked about presumptively constitutional laws, that somehow means they're constitutional. It's not true. The language about presumptive laws involving sensitive places and felons in possession and commercial regulations, these were presumptively constitutional in Heller and to some degree in Bruin, because they're talking about something known as dicta. It wasn't central to the holding. And there's some passing reference saying we're presuming these things are constitutional. But as you know from the criminal law and law generally, presumptions can be rebutted and overcome. We understand this as a matter of common sense. If you think about it, again, if you're indicted in a criminal case, you're presumed innocent, but if the evidence is so overwhelming that beyond a reasonable doubt you've committed a crime, you can be convicted. That presumption of innocence can be overcome. So too, when the anti-gunners like to use this language about laws are presumptively constitutional, and they quote Heller and Bruin, again, those presumptions can indeed be overcome, and that is exactly what the judge here indicated. The court said, again, she talks about presumptions and presumptively, but she's like, yeah, but I still have to do the work and see, has the government overcome these presumptions? Or I should say, has anyone overcome these presumptions, or are these true in this case? And of course, with these specific areas, she said they're not true, that these areas cannot be, government cannot ban the carrying of guns in these areas, and she declared that, at least at a temporary basis, to be unenforceable under the Constitution. Beyond that, the court also went on and specifically says that Bruin's directive is clear. Once an individual's conduct is covered by the plain text of the Second Amendment, the burden is on the government. The burden is on the government to establish that the regulation is consistent with the nation's historical tradition of firearms regulation. This is very important, what the court just indicated here. It's the historical tradition of firearm regulation. Why is this so important, and why am I emphasizing this? Because it's not about being consistent. The government can't just come forth and say it's consistent with some history professor or some quote-unquote history expert says about American history. No, it's very precise. The government has to come forward with founding era historical laws, regulations on the books, to show that the modern day gun control law or regulation is consistent with the founding era laws and regulation. They can't just cite to some anti-American historians saying, oh, well, in the 18th century, there was this trend. No. Point to the regulation, point to the law is exactly what the court should be saying to those government lawyers. Show me the law that's consistent with this. Show me the law at the time of the founding. If you can't show me the law, I don't care about your historical stories or epochs. Again, it doesn't matter what the history is. It's what the historical laws and regulations at the time is. Specific historical question, not some generic, tell us about the nature of American life or the narrative of American history or the story arc of America. None of that matters. Specific things the Supreme Court says the government has to come forward with. And if they can't come forward with it, they lose. When in doubt, throw it out. When in doubt, throw it out. And the last point, I think the judge makes a very interesting point here on page 30, where she says about businesses and concealed carry of guns. She says, insofar as businesses did not have to display a sign prohibiting the carrying of firearms on their premises, the individual plaintiffs could carry in the past freely, and the businesses would unlikely be aware that the individual plaintiffs were concealed carrying. Exactly right. That's the idea of concealed carry. So anyone that is skittish around guns because they've been propagandized against guns by their urban elite professors or teachers, if you're skittish around guns and your guns are concealed, they don't even know it's there. So you have the benefit of protecting yourself and your family and others. But no one who's nervous at the sight of guns, which is kind of absurd, but some people are, because they're not familiar with guns, because they grew up in areas that were anti-gun and they never even thought about guns. So they're scared of guns, and I understand why. If you have no familiarity with the subject, it's like an alien landing here trying to understand nuclear power or something. I get it. Nevertheless, this is how you balance the equities. You allow people to conceal carry, so it doesn't scare people that are scared about guns, and at the same time, you get to protect yourself and your family. So that's why I think that's all appropriate in modern American life. Okay, folks, again, good news out of Hawaii. I know we had some bad news with the Supreme Court. I don't think it's terrible news out of the Supreme Court, but we had good news out of the Hawaii Federal District Court today. So that's very good news. Congratulations again to Alan Beck and to the Hawaii Firearms Coalition and to the other plaintiffs in this case. And remember, every day in America where you can buy guns and use our firearms is a great day for American freedom and for human freedom here in this country. So never forget that, and always look on the bright side, because there's a lot to be excited about and happy and optimistic for, that we have the right to keep and bear arms. And as long as we have the right to keep and bear arms here in America, we cannot be enslaved. Never forget that. Okay, folks, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.